Theranos CEO Elizabeth Holmes wants a new trial in her fraud charges, but will she get it? Hi, I'm Drew Page. This is Drew Page channel. In this video, we're going to look at what are the requirements for a new trial, what has to be done, and what is the likelihood that Elizabeth Holmes is going to be granted a new trial. If you find this video helpful, please subscribe to the channel, like the video, hit the notification bell. Thank you so much for the support of the channel. The new subscribers, welcome. And please continue to post in the comments. I love to hear from you. I love your feedback, and I try to respond to every single comment. So please keep those coming. And with that said, let's jump into the video. Yesterday, Elizabeth Holmes, through her attorneys, filed a motion for a new jury trial. And they did so because of what they claim is, quote, fresh evidence. What happened is that one of the witnesses, who was an employee of Theranos and worked with Elizabeth Holmes, showed up at Elizabeth Holmes' house and was attempting to make contact with her, and instead ran into Holmes's significant other, William Evans. And allegedly, according to Evans, this other witness who was relied on heavily by the prosecution at trial and whose credibility was touted in the closing argument by the prosecution and even was referenced by the judge in a previous motion to set aside the verdict, said that he had regrets about what happened. He wanted to sit down with Holmes to see if they could come to some sort of peaceful understanding, that they could work things out and all of this. There's a claim that this witness also contacted Holmes's attorneys and wanted to speak with Holmes to see if they could work things out as well. On this basis, the attorneys are indicating essentially that the testimony that was given by this witness should be deemed incredible, and that this was information and evidence that would not have been attainable at the time of trial. And on this basis, they are seeking to set aside the verdict and request a new trial. So what is the likelihood of that happening? Well, we have to look at Rule 33, which is the rule of criminal procedure for the federal court, since this is a federal case. So let's look at Rule 33. Federal Rule of Criminal Procedure, Rule 33 says, upon the defendant's motion, the court may vacate any judgment and grant a new trial if the interest of justice so requires. If the case was tried without a jury, which in this case it was tried with a jury, so this doesn't matter, but just for your knowledge, the court may take additional testimony and enter a new judgment. Now, there are time constraints in order to file this motion. For newly discovered evidence, any motion for a new trial grounded on newly discovered evidence must be filed within 3 years after the verdict or finding of guilty. If an appeal is pending, the court may not grant a motion for a new trial until the appellate court remands the case. Now, if they aren't able to show newly discovered evidence and there's some other ground they're seeking to set aside the trial, then any motion for a new trial grounded on any reason other than newly discovered evidence must be filed within 14 days after the verdict or finding of guilty. With this information in mind, let's look at what it is that they're trying to request. They're trying to say that this evidence of this witness having this change of heart, these regrets, is newly discovered evidence, that this is evidence that could not have been deduced at the trial, that this was evidence that was not available to the lawyers for Elizabeth Holmes, and that they could not have addressed this at the trial, and therefore this is newly discovered evidence. Here's the thing though, with what we're being provided with the news story, we're getting this information based on what Williams Evans is saying and what the lawyers are saying that this witness has said. What they likely will have to do is put this person on the stand to deduce whether this person was in fact coerced, because one of the things they're claiming that he says is that the prosecution was twisting his arm and making him say things that he didn't really feel comfortable saying. But there isn't any evidence at this time, at least based on the articles I've seen, and obviously if you see something else, please put it down in the comments, let me know. But I haven't seen anything that indicates that this person says that the testimony he gave was not in fact truthful and was not credible or correct. Even if the prosecution was saying that they were making him testify and all these other things, but if he was testifying truthfully and he wasn't testifying in a manner where his testimony would be different if he wasn't coerced than how it actually turned out, then that may be a different scenario. So we'll have to see whether he is going to claim that he was actually coerced into giving false testimony, or if he was just being threatened to give truthful testimony. If the person is going to get on the stand and say, well, I actually told the truth, but I just didn't want to, well, that's a different scenario altogether. You're probably not going to get a new trial for that. But if it comes out that the prosecution was threatening this person, coercing this person to give false testimony that was helpful for the Commonwealth and detrimental to the defense, well, then that may likely be newly discovered evidence. Because that would be information that was not available. The inner workings between the prosecution and this witness was not necessarily something that may have arisen. Now, they could have cross-examined the witness and asked him, so, were you threatened or forced to give testimony? Are you telling the truth? Are you giving credible testimony? Were you coerced or any of those types of things? And that could have been dealt with possibly at the trial, and that's probably what the prosecution is going to respond with and try to send it down to that part B where it says a motion to set aside on any other ground, because they are beyond the 14 days of the trial of the finding of judgment. So they need that 3-year window, so they have to call this fresh evidence. So the issue is going to be whether he was coerced into giving false testimony, or if this is just a buyer's remorse, not wanting to have to testify, but simply feel like they were threatened or forced to have to give testimony, but the testimony is in fact truthful. So we'll have to see how that plays out. So wanted to jump on here and give you that information since that was breaking news today. Let me know in the comments, do you think that this is worthy of a new trial? Do you think that this is newly discovered evidence, or do you think this is something the defense attorney should have been able to figure out on cross-examination at the trial? Let me know in the comments. Please subscribe to the channel, like the video, hit the notification bell, and until next time, stay tuned.